We have one case on our oral argument calendar this morning, and that is Steve Simon, Minnesota Secretary of State petitioner, Melissa Hortman et al. Petitioners, versus Lisa Dameth, respondents. The record should reflect that Justice Procaccini is recused from this matter, and therefore he will not participate in any way in the deliberation or the decision of this matter. Also, for the record, let me just make sure we've got counsel appearances. Ms. Kramer, I see that you've got 20 minutes for your introductory comments, and then Mr. Zoll, you will go next with 10 minutes, and then Mr. Nelson. Where are you, Mr. Nelson? There you go. Thank you. Mr. Nelson, you have 25 minutes for the respondents. Ms. Kramer, as I'm sure you're aware, you have rebuttal time, and I see you as having 5 minutes for rebuttal. Is that correct?
That's correct, Chief Justice.
Okay, thank you. As I'm sure counsel know, you'll each have 3 minutes of uninterrupted time to make any opening statements that you would care to make to the court. At the end of those 3 minutes, if you have not stopped, I will stop you to see if the court has any questions. And so with that, Ms. Kramer, you may begin if you're prepared to do so.
Good afternoon. May it please the court, counsel. My name is Liz Kramer. I'm our state solicitor general, and I'm here today representing the Secretary of State, Steve Simon. I want to thank all of you for expediting this important legal question. Petitioners asked this court to resolve the interpretation of 5 words in the Constitution, a majority of each house. The question is whether a vacancy in either house reduces the number necessary for a quorum, or whether the quorum number is static. Quorum does not change with vacancies in Minnesota. That's true for at least 3 reasons. First, the plain text of the Constitution. We start with the 5 words, a majority of each house in Article 4, Section 13. We then look to Section 2 of that same article, which fills in the meaning of each house by saying the number of members of the house shall be prescribed by law. And when we would look to the law, we find the number is 134. So applying those definitions from within the Constitution itself, the 5 words mean a majority of the 134 members. Second, while this court has not had to interpret Section 13, it has twice interpreted constitutional language requiring a 2/3 vote. And both times, this court interpreted that language to mean 2/3 of the largest possible denominator. Eastland versus Gold said 2/3 of the legislature is 2/3 of, quote, all the members of the branch, end quote. And State versus Wagner said 2/3 of the House, our last same 3 words, means 2/3 of the whole membership of the House, end quote. The same should be true here. A majority of each House means a majority of the whole membership of the House, which includes vacant seats. That honors the drafter's insistence on equal representation and on requiring a true majority to pass legislation. Third, and finally, every state high court to interpret these same 5 words have concluded it is a static number that does not change with vacancies. Those are Florida, Delaware, and Kansas, the cases we cited in our brief. For these reasons, the Secretary of State urges the court to issue the writ declaring that 68 members of the House are required for a quorum. With that, I invite your questions.
Counsel, it seems to me that your reading is a reasonable one. Your reading of the quorum clause is certainly a reasonable one. It's a plain language, straight sort of statutory interpretation. But it also seems to me that respondent's position is at least equally reasonable. And what troubles me a little bit about your position is that when you look at the other provisions of the Constitution, in particular Article 4, Section 22, as respondents do, regarding the number of votes to pass a law, it talks about a majority of all the members elected. And respondents spend quite a bit of time in their brief explaining why that's relevant, and it does seem to me that it is. When you look at our cases like Eastland and particularly Peterson, where we draw the distinction that the respondents ask us to draw here, that it's a majority of those who are elected to that position. In other words, the current membership. What do we do with that? What do we do with Peterson in particular and precedent along those lines that really seem to undercut the petitioner's position?
Chief Justice, Peterson versus Hoppe is simply not useful in this circumstance. That case interprets different words, so it didn't say of the House at all because it was a city charter, and it said, as I recall, all members, not any language like we have. So it was looking at different language in a different document, a city charter, and under very different circumstances. In that case, the Supreme Court seemed to understand that there was specific voter intent behind that amendment, that vacancies should be allowed to be filled quickly, and that really informed the court's analysis of
Counsel,
that part.
Isn't it instructive, because this is a highly unusual situation that we find ourselves in, and so when we're looking for guidance, I mean, doesn't it at least provide some guidance or be instructive to the court?
Justice McCaig, I think not, and that is because you have two cases that are much more relevant and persuasive here, which are both the Eastland versus Gould case and the Wagner case. Again, both of those were interpreting language in our state constitution. So looking at the same document that you are looking at now, and both of them were looking at language about what proportion of the whole is required to do something. In both of those, it was 2/3. Again, one was 2/3 of the legislature, and one was 2/3 of that House. But both times, this court said that means the entire membership, every person in that branch, which has to include vacancies.
Did it really? Well, I want to get to Gould after this, but just can you explain the distinction between language all members of the city council, and here it's a majority of each house. Now, Peterson, it was a majority of members of the city council. What's the difference? What's the implication of members that makes that different? Can you just explain that kind of in practical? I understand the words are different, but can you explain why those are not the same?
I think the starting place is that when you say of the House, you're talking about an institution, a body that encompasses all potential seats in that body. And that's important because each of those seats is intended to represent a certain proportion of our voting citizens. Whereas all members means people, and it can be different based on people who are present or absent or abstaining or conflicted out.
So it's okay. So the whole question in Peterson is between members and members elected, as opposed to this different language, which is House. And that's why you're saying it's not relevant. The language difference, I mean, you're also saying it's not the Constitution, I get that. But the language differences are, the language in the Constitution is not the same as the language of either option in Peterson.
As I recall, that's correct, Justice Stevenson. The other thing I want to point out, though, which I think really distinguishes our situation from Peterson, is the way the different language is used in Article 4, and I have it here to make sure that I don't get it wrong. But if I could direct you all to Section 23, which of course is not at issue today, but in that, Section 23 of Article 4 is the one that talks about the 2/3 override. 2/3 that it requires, to override a governor's veto, whether that be of a bill or of a line item expenditure. Within Section 23, it twice refers to 2/3 of that House, but in that last paragraph, it says 2/3 of the members elected to that House. To me, those different usages within the same section of Article 4, which is the article we're looking at, suggest that in our Constitution, the framers were using those phrases interchangeably, and that they didn't see a big distinction between saying all the members elected or of the House or of all the members. And so they weren't perfectly consistent, and that's okay. We can see what they intended by that.
But counsel, aren't the public policy considerations here similar to what the court considered in Peterson? And if we're looking at this statute as possibly ambiguous for the reasons indicated by the chief just moments ago, don't we have the same question here? I know in Peterson they talked about it was important to define majority in that particular way so that they had the power to act to prevent deadlock. Isn't that exactly the same problem we find ourselves in here?
Your Honor, I find the public policy cuts the other way. And that's because we want to ensure we have a rule of the quorum that aligns with what the drafters intended. And we have an indication of what the drafters intended in Section 22, which is that majority rule was very important. Unlike most constitutions in the country, and unlike the federal constitution, the Minnesota Constitution says a majority of the whole body has to vote in favor of legislation for it to pass. I don't think anybody in here disagrees with that that's the 68. And yet...
Oh, but counsel, it depends on what you're taking, how you're defining that, because I think respondents would say, no, it's a majority of the remaining members. It's the people who are actually there present. And that seems to me to be one of the public policy issue, going to Justice Hennessy's point that Peterson was getting at. Peterson was concerned about permitting what was effectively a minority number of members from wielding power over the majority. And it does seem, in a way, that's a little bit what's happening right now, because the Democrats are not in the majority. And it's the minority, like right now, and it's the minority suddenly wielding power and over the minority and dictating action. Isn't that what Peterson was concerned about? And how is that different from what's happening now?
I want to be careful, and I know you all want to be careful, that whatever rule comes out of today isn't limited to today's circumstance. So we want to make sure that the same principle that animated our drafters, which was that a majority of people voted for by Minnesotans are the ones that actually act to pass things, that carries through all of this. And so when this court says that a quorum is 68, the legislature will align itself to that, and it will force people to make compromises. If the court were to go the other way and say that a quorum can be reduced when there are vacancies, that would create an odd situation that anytime, for example, a member dies or a couple of members die, that a group that otherwise would have been a minority faction would all of a sudden be able to exercise control in a way that the people didn't authorize by their votes. So I think that's why the public policy cuts the other way.
Excuse me. Speaking of the intent of the drafters, beyond the plain language, and I think it's been suggested here that there are reasonable interpretations on both sides as to the plain language of this provision, what is the best evidence of what the intent of the creators of our Constitution meant by this provision?
I think that best evidence, well, we all know there's not a lot of evidence in terms of what actually happened at the debates and at these constitutional conventions. So putting that aside, when we have your Eastman versus Gould decision, that's not so long after the Constitution was drafted. I think the language in there is very clear that this court thought the denominator for all types of votes, right? It says there's only two types of votes, a majority vote and a 2/3 vote, and they both mean of the whole, of the entire membership of the body. So I think that's good evidence. I also think the legislative or the common understanding of the legislature over time is good evidence here. And we have, we pointed the court to the legislature's own nonpartisan document about how it legislates, suggesting it views the denominator as unchanging with vacancies. And we pointed the court to Masons, which is something the legislature itself uses to fill in gaps like this in parliamentary procedure.
Counsel, I'd like to ask you about the justiciability issue that your opponents raise. As I understand their argument, they're suggesting that if we decide this case, we're essentially opening up a can of worms that might not be able to be closed again. That, in other words, this court could be viewed by parties as a place to resolve political disputes. In other words, get involved in the two other branches of government. And I'm asking if you could help me out by articulating why, if we adopt your constitutional interpretation here, why we would not be inviting that type of response from parties in the future for other types of political disputes between branches of government or potentially parties.
Justice Moore, I'll start with Palmer versus Perpich, which is a case that this court decided in a very similar circumstance in 1978, when the question was the Senate at that time duly organized, or was a constitutional officer usurping the role of the legislature? This is basically the same dispute. So this court has precedent of stepping in situations exactly like this. Second, the fact that this particular question has never come up in the past, what are we at, 175 years of this Constitution, I think is good evidence that people are not likely to bring it up again and not incentivized generally to come to the court with these kinds of disputes, and instead find ways to work together.
Can I ask you about some information that we didn't know before that came up in the affidavit? So I guess my question is, did Mr. Johnson have a valid certificate of election? You seem to make an argument about mootness, that we don't have to decide this case. And there's an affidavit, and 134, apparently the secretary presented 134 certificates of election to the House. And then I'm not sure who, maybe the clerk, I don't know who made the decision about that it was only 133. So is your position that Mr. Johnson had a valid certificate of election on January 14th?
Justice Thiessen, I'm not trying to take any position about that. And my colleague, Mr. Hartshorn, was here ably arguing those issues before. My point in raising that case was simply to say that there might be some interplay in these issues. And if the court has decided, for example, that Mr. Johnson was not legally able to resign, or that there was not a true vacancy, that really alters the understanding of what happened on January 14th. And I do want to amend, my brief said it was moot. Some of the requested relief would still need to happen. Right. No, I get that. Yeah. Okay. So you don't have a position on whether his certificate of election was presented to the House before and on January 14th? The secretary doesn't have a position on it. The declaration says what it says, Justice Thiessen. Okay. Do you have any position on whether the clerk pro tem has the power to declare that a certificate of election sitting there is not to be accepted? I do not have a position on that. That's not something we're asking the court to decide today. The issue today, again, is whether a majority of each house can be reduced by a vacancy, unless, of course, the court concludes there was no vacancy, and so that particular issue doesn't need to be decided. But you don't have any position on it? On whether there was a vacancy, I do not.
So Ms. While we're talking about threshold issues, respondents devote a fair amount of landscape to encouraging this court not to take up the interpretation issue. And one of the arguments presented in their brief is that the secretary does not have standing here. And I'm just wondering if you could walk us through your argument that the secretary did experience some injury in fact as a result of his statutory obligations and what happened on January 14th. I'm not totally clear on how that constitutes an injury in fact.
Thanks, Justice Gaitis. I'll start with staying in Article 4. I think it's Section 15 that says the legislature can essentially decide how presiding officers are elected and kind of how the legislature gets out of the starting gate each session. And it has done that in at least 3 statutes. It's like 3.05, 3.06, and 5.05. And together, those say that the Secretary of State begins as the presiding officer, and he has to do that until a speaker is elected. And those statutes say a speaker can't be elected without a quorum. And so Secretary Simon was trying to fulfill his statutory duty to remain presiding until there was a quorum that could elect a speaker.
So is the injury that he was unable to fulfill a statutory duty? Is that
Yes.
Is that what the argument is?
Yes, thank you for crystallizing that.
So counsel, if we hold that the quorum is what you say it is statute 3.96 then unconstitutional, the statute regarding if there is an attack that uses the language that the quorum requirement for the legislature is a majority of the members of each house who convene for the session? And how can a statute provide an exception to the Constitution?
Justice Hennessy, I don't believe anybody has briefed that issue, and that's not a part of what we're asking the court to decide today. I think you're certainly right. It raises an important question, but one that this court should leave for another time. I do want to get back to the public policy argument for a moment. We already, my time is up.
Your time has expired. You can do it on rebuttal.
Thank you.
Thank you. Mr. Zoll.
Thank you, and may it please the court. I'm David Zoll of the law firm Lockridge, Grindle Nowen, appearing on behalf of petitioners Hortman, Long, and Hollins. The issue today is neither political nor partisan. It's a question of constitutional law. The question is, what constitutes a quorum for the Minnesota House to transact business? And as explained by counsel for Secretary Simon, the answer to that question lies in the constitutional text itself. Article 4, Section 13 provides a majority of each house constitutes a quorum to transact business. Section 13 refers to a majority of each house. It doesn't reference members. It doesn't reference members elected. It refers to the House itself. And in that sense, it's referring to the constitutionally created body of state government. In Article 4, Section 2 provides that the number of members who compose the Senate and the House of Representatives shall be prescribed by law. That's the constitutional text which guides this court's decision and analysis in this matter. And because Minnesota Statute 2.021 provides that the House of Representatives, that constitutionally created body of state government, is composed of 134 members, we know that a majority of that number, that is 68 members, constitute a quorum of the Minnesota House by law and without exception. And this is for good reason, because as counsel for Secretary Simon explained, it ensures that before the House takes any action, at least a majority of Minnesotans are represented in the House chamber. That's why the Constitution prescribes and defines that a quorum is based upon the constitutionally and statutorily prescribed number of members, not the members that have been elected, not those who are seated, not those who are sworn in. It is based upon the prescribed number of members in statute, the members of which that constitutionally created body is composed. I'd like to address a few of the questions that the court raised for counsel for Secretary of Simon. And I want to start by addressing questions regarding the language relied upon respondents. You heard a preview of what I'm going to argue. They rely on language both within the Constitution and within other cases that this court has decided that refer to members. A majority of the members of the House, a majority of the members elected. The key that you need to ground your analysis in this matter, though, is that Article 4, Section 13 simply refers to a majority of the House, of that constitutionally created body.
Counsel, I'm going to stop you there to see if the court has any questions.
Counsel, can you address the injury in fact for your clients, please?
Yes, Your Honor. Petitioners are duly elected members of the Minnesota House of Representatives, and they have been injured by the conduct taken by respondents and 64 of their colleagues to purportedly organize the House in a manner that is inconsistent with the constitutional prerequisite that a quorum be present at that time. They have been injured because respondents have taken a temporary advantage, purportedly, to organize the House in a manner that prejudices the ability to advance legislation and frankly calls into question all actions taken by the House. If they organized in a manner that is inconsistent with the constitutional requirements.
But respondents here point out that the injury is the result of petitioners' conduct in not appearing at the legislature. How are we to take that fact into account in our standing analysis?
Your Honor, I don't know that that is relevant to the standing analysis. And here's the point. When faced with the denial of a quorum, respondents and their colleagues could have abided by the constitutional requirements and Secretary Simon's adjournment of the legislature, of the House. They didn't do that. They picked up the gavel, declared a constitution to be present, and purported to organize themselves as the House in a manner that is not authorized because there was not a quorum present. The conduct that brings this matter before the court is the manner in which respondents responded to the lack of a quorum on January 14.
Even if it's not relevant to the issue of standing, is there argument that the conduct of your clients somehow brings them to this court with unclean hands relevant to whether we issue an extraordinary writ?
It does not. This was addressed in our brief. It was addressed also in Secretary Simon's brief. The decision to deny a quorum by the DFL caucus is not an unlawful action. It is not unfair. It's not unjust. It is a decision that they made in order to ensure that when the House is duly organized, it represents the will of Minnesota voters. That decision that they made to take that action that they are entitled to do in no means creates unclean hands in the sense that it would prevent this court from ruling on the petition for a writ.
But counsel, even if we say that there was the injury in fact, I mean, this court is not going to give weight to like returning them to this power sharing agreement that was arranged at one point. So how does that impact our decision-making process?
Your Honor, although that is referenced in our petition, we're not asking this court to enact the power sharing agreement that was negotiated between the Democrats and the Republicans. What we are asking this court to do is to determine whether the purported action of organizing the House in the absence of a quorum was legally valid. It was not, and the remedy for that is to restore the status quo as it existed.
Well, the status quo could be restored if they went to the legislature and created a quorum. So as to the second part of the standing analysis, we have to consider whether we can provide redress for the problem that's been created. And help me out with how we can do that with our decision.
The existence of a quorum at some future time does not provide a remedy for the illegal conduct that has occurred to this point. Is it possible that the legislature could take subsequent actions to remedy the illegal conduct, duly electing a speaker in the presence of a quorum or appointing committees or any other actions that were taken in the organization of the House? That could happen. I will concede that. But the remedy that we are asking for this court is to deem that those were invalid, that those actions are a nullity.
Counsel, following up on that, what if we do that? If we grant you the remedy that you're seeking, tell me what happens as a practical matter. What happens tomorrow? What happens the next day?
Secretary Simon, as the presiding officer of the House, pursuant to Minnesota Statutes 5.05, will convene the House. If there's a quorum present, the House may take action. In the absence of a quorum, the House will adjourn until a quorum exists.
So that could go on day after day after day. Is that right?
Your Honor, that is how the Minnesota Constitution is set up. That there must be a quorum in order to transact business. And in this context, it's happening where there's an evenly split legislature. It could just as well happen where it's tipped significantly in favor of one party or the other. You know, a party that has a 70 to 64 majority could sit out for whatever reason, deny a quorum so that action isn't taken. And
can I ask you about Gould and Wagner, and those cases don't seem to talk about the question at issue in this case at all. They say, each of them say a majority of membership of the House, majority membership of the body, but that's not the language. It doesn't answer the question what that means. Is it 133 or 134, for example? I mean, that was only worried about like the majority of a quorum. Like if you have a quorum of 69 people, 2/3 is not 2/3 of 69, it's 2/3 of the membership of the House. But that doesn't answer the question of, is that 134 or 133 in this case? And do vacancies count or not? I just don't get how those cases have any bearing.
Those cases are not determinative. You're correct, Your Honor. They did not address the precise question in front of this court, which to my knowledge, this court has never faced, of determining whether under the Minnesota Constitution you account for vacancies and determining whether a quorum exists in the House. Again, I counsel you to return to the plain language of the Constitution, but they are instructive in that they suggest that what is intended is a vote of particularly when we look at the language in Article 4, Section 23 regarding an override of a veto that refers to 2/3 of the House. It's referring to, again, that constitutionally created entity, not to its individual membership.
Go ahead, Justice Thiessen.
That's fine.
Counsel, can you explain to me why we shouldn't be following the interpretation of the U.S. Supreme Court of what happens with the U.S. Constitution, which has very similar language? Why does that not control what we do? Can you walk me through that?
Yes, Your Honor. And what I would point the court to in that regard is the opinion of the justice's case from the state of Florida, 251 A. 2nd 827, because that lays out in detailed stepwise manner the distinction between the relevant provisions of the Minnesota Constitution and the U.S. Constitution. Why do I say that a Florida court addressed those distinctions? It's because the pertinent language of the Minnesota Constitution is identical to the language of the Florida Constitution as it existed at that time. And it really turns, and I apologize, I'm over time. But
I was about to stop you, counsel, but I'm letting you answer Justice Hennessy's question, but please wrap up.
The key provision in that analysis and for this court's analysis is how the Constitution defines the membership of the House. In Florida, it's defined as a set number, just as it is in Minnesota. In Minnesota, it's as prescribed by law and then set by law at a set number. The U.S. Constitution defines members of the legislature or the legislative membership is the members who are chosen by the states. And that is a number that can fluctuate. If a state fails to choose a legislator, then the whole body is reduced by one. In Minnesota, that doesn't occur. If there's a failure to elect, by operation of the Constitution and statute, that number remains static at 134. With that, my time is concluded. I respectfully request that the court grant the petition.
Thank you, counsel. We'll now hear from Mr. Nelson for respondents.
Good afternoon, Your Honors. May it please the court, counsel. The judicial power includes reviewing the validity of statutes. It does not include reviewing the legislature's organization of itself or the legislature's leadership choices. That is the legislative power, which our Constitution vests in the legislature, not in the judiciary. That, of course, is exactly the power that petitioners are asking this court to exercise here in a way that, to our knowledge, is unprecedented in history. The court cannot do so under our separation of powers. Likewise, petitioners cannot and should not be able to invoke this court's extraordinary writs jurisdiction to address an alleged quorum problem that is of their own making. When there is a question about a quorum in one of the Minnesota houses of the legislature, the Constitution contemplates exactly what should happen. In the first place, the members of the legislature should come to the Capitol and do the jobs they were elected to do. Failing that, the members who are attending the sessions, whether they're a quorum or not, have the constitutional power to compel the attendance of absent members. The petitioners here are actively thwarting both of those constitutional remedies. The legislative petitioners are categorically refusing to participate in the legislative process that they were elected to, and Secretary Simon is actively, or at least purporting to actively prevent the House from exercising its constitutional authority to determine the presence of a quorum, and quorum or not, to compel the attendance of absent members. The petitioners should not be able to leverage these counter-constitutional actions for a favorable judicial judgment on exactly the same issues. Finally, if the court reaches the merits, the question is whether a quorum of the Minnesota House of Representatives is a majority of current members or a majority of total seats, including vacant ones. Different jurisdictions have taken different approaches to that question, but Minnesota has long since made its choice. It's the same choice made by both houses of the U.S. Congress. A quorum is a majority of the members currently sitting. I was surprised to hear General Kramer talk so much about Eastland versus Gould, because although that does talk about what is the House, it also talks about what is a quorum of the House, and the court articulated the rule we're advocating for here. Lest there be any doubt, the court reaffirmed in Peterson versus Hoppe. Yes, that's what we were talking about in Eastland. And the court again most recently repeated that rule in its RAM development case. Petitioners give no reason to upend that settled rule of Minnesota law. So the petition should be denied on the merits, even were they not dismissed on jurisdictional grounds. I welcome the court's questions.
Well, counsel, on the justiciability issue, I don't think I saw quoted or cited, in your brief, Marbury versus Madison. I mean, we go back to sort of first principles, which basically states that it's the province and the duty of the judiciary to decide what the law is. And we certainly are hesitant, and rightfully so. We should be exercising judicial restraint when it comes to dabbling into the business of a co-equal branch. On the other hand, there are times, and we certainly have done this here in Minnesota, where the courts are required to step in. I mean, we said as much in Cruz Guzman, where we stepped in there to resolve a dispute in the legislature, saying they weren't following the Constitution. They had a constitutional duty to abide by the education clause. We said, so we've said that before. So I guess where I'm going with this is, if this isn't a case where there is an urgency, as we've talked about in some of our case law, to step in, what would be? Because what we have is a co-equal branch of government that is completely dysfunctional, that is not doing the will and the work of the people of Minnesota. Isn't that an instance where, if not the judicial branch, who steps in to resolve that?
Well, I think the House itself resolves the question, which is the doctrinally correct answer. But let me start by
It hasn't.
Well, let me start by addressing the question of what would happen next.
Well, first of all, what is the House if you're wrong? There is no House.
I don't think.
I mean, how do you get to resolve it if you don't have a quorum to begin with?
I think that, well, the Constitution contemplates that the House can meet without a quorum, and it's still the real House, right? So I don't think anyone disputes that the House, when several dozen legislators met in the Capitol at the
they can meet to do what? To compel other people to come back.
They can compel other people to come.
So
they also
they didn't do that. Okay, so this is the thing that I don't get. How can they make a decision when they have no power to convene? I mean, you're putting the cart in front of the horse, it seems like.
Well, I think that begs the question of whose job is it to initially decide whether there's a quorum? I mean, the courts always have, for instance, jurisdiction to decide their own jurisdiction, and if answering the quorum question is within the legislative competence,
doesn't the quorum question that's been presented here require us to interpret our own state constitution? Isn't that our thing? Isn't that what we do as the Supreme Court? So why is this anything beyond an ordinary question of constitutional interpretation that we can deal with?
Yeah, thank you. The separation of powers contemplates that there are certain very limited questions that are committed to one branch or the other, right? It doesn't mean that the Constitution doesn't require anything. I think a great example is the executive. This is under the federal Constitution, but if the same principles apply, the executive has a duty to take care that the laws be faithfully executed. No one would say that duty doesn't mean anything, but we do say that the courts don't step in and try to enforce that. And we would say this is a similar situation.
But counsel, if you're right, we never would have decided Palmer the way it was decided. I mean, essentially what we said in Palmer is there's a dispute here about the authority of the executive branch, in that instance, the lieutenant governor, to come in and break a tie in the Senate. And one could argue that that was interfering in the workings of the Senate, which is what you're arguing. We don't have any right or business in stepping into the House's determination of who the speaker should be. But that's effectively what happened in Palmer, because we were doing much like Justice Gaius has referred to. We were interpreting the Minnesota Constitution. And I guess I just don't see the difference ultimately between what we did in Palmer, where we made it very clear that there are unique and extraordinary circumstances where the judicial branch must step in.
Palmer was an interbranch dispute, Madam Chief Justice. It was the lieutenant governor trying to assert power in the legislative branch that he did not have. So the court's ruling on that, on where those lines of power broke down, was not an attempt to exercise legislative power. Here, the House, and everyone agrees, that was a meeting of the House. The question is whether its actions were procedurally proper, but the House chose its leadership, and the court is being asked to second guess that. That's a purely intra-branch, purely legislative determination.
Well, I don't know. I mean, in your brief, you talk about the fact that Secretary Simon has, I forget the language, engaged in some kind of egregious executive branch overreach or something, words to that effect. So you've pulled in the executive branch as well, and you're challenging the Secretary of State's authority to preside, as Statute 505 says that he can. So I grant you that it is primarily a legislative dispute, but you've pulled in the Secretary of State as well. So now you've got the executive branch involved too.
Well, there is no constitutional basis for the Secretary of State to preside over the legislature. So I think, I mean, if that were the issue that the court were deciding, then there would be a basis for deciding that does the Secretary of State have the constitutional power to do that?
But
That's
Counsel,
not what's
aren't
being
we
argued.
deciding what a quorum is under our Minnesota Constitution? And if we don't decide that, you're saying that we leave it to the legislature to decide that for themselves, to interpret the Constitution, and no one can challenge that?
So this is an important distinction, Your Honor. The court has the power to review the validity of statutes. If the legislature tries to enact a statute.
Well, and the Constitution.
We can't interpret the validity of the Constitution? Yeah.
No, certainly. No question.
I mean, you started your whole argument only focused on statutes too, which I thought was weird, but go ahead.
So the court has the power to determine whether statutes comply with the Constitution. That's the tenor of what I'm saying. And the court, of course, that includes interpreting the Constitution. So if the legislature attempts to enact a statute, the court does have authority to look into whether it was constitutionally enacted. I think the case is Bull versus King, if I'm not mistaken. It's from the 1930s, and the court has consistently applied that. That is a different set of rules. This case does not implicate those rules. This case is about whether the court can look into the procedural propriety of the House's internal organization decisions.
But you're separating. That distinction is such a fine one. I mean, you're peeling that onion really thinly, because it isn't just about the House's internal regulations and operations, because the House has to conduct that business pursuant to the Constitution. And so it seems to me that circles you right back around to, is the House doing so legitimately? Is there a quorum? And that circles you back around to the Minnesota Constitution. So I don't know that you can just put it in this little bitty bucket of the House's internal regulations. Because again, I don't think Palmer would have come out in the way that it did if that were true.
Or Gould.
Or Gould.
So I mean, the House certainly has constitutional obligations. That, I mean, every member of the House takes an oath to uphold the Constitution, and they're required to consider that in how they organize themselves. That doesn't mean that there are not certain instances where the judge of what the Constitution requires isn't the House. You know, the Constitution contemplates that this court will do certain things, like hire a clerk. I think that's a pretty good analogy, because the Constitution does specifically talk about that. If the House were trying to pass a statute to say, no, the court didn't properly hire their clerk, we're removing the clerk, I think that would pose a separation of powers problem.
You know, Counsel, I'm sorry, go ahead, Justice McKay.
Well, I'm moving on to a different topic,
Okay.
so if you have something more, go ahead.
Thank you.
I know.
Okay. One last question on the separation of powers. It does seem to me that not deciding in some ways is making a decision.
It's deciding to let the House resolve these things.
And
could the House make a different decision in another biennium? Define the quorum differently?
Well, one House doesn't formally bind another. I mean, houses do, you know,
I mean, you mean like the House of Representatives doesn't bind a future House of Representatives?
Correct.
Yeah.
Correct. I mean, there is a system of precedent that's recognized. Heinz's precedence is something that legislators look at, right? That's for the federal Congress, but houses certainly should think about what previous houses have did.
But they could.
That. I think, but just the same way this court can overturn its own decisions, a later House could overturn an earlier House's decision.
I have a question. Okay. Thank you. Thank you, Chief. I have a question that sort of goes back to a question that Justice Thiessen posed, and that is, assuming we're in Minnesota, there was the snowstorm, highly unlikely, I realize, and nobody in northern Minnesota and no representatives in southern Minnesota can make it in. And so there are 67 members within the Twin Cities who show up. Can they transact business, and if so, what business can they transact?
I think that really well illustrates the relatively low stakes of the question here and why it can be left to the legislature without creating any kind of crisis. So yes, those 67 could transact business. They could do things like create committees, elect leadership, schedule readings on bills that the Constitution requires, that sort of thing. Of course, as soon as the members from outstate got in, if the majority changed hands, as night follows day, that would result in a change in leadership, perhaps a change in rules. Everything could be rearranged because it's a democratic body, majority rules. Now, the other point is that Under our current understanding, that 67-member majority could not enact statutes. Justice Thiessen is right. I think that the cases don't expressly say that it requires a majority of all seats in the House to do these things. So the court has never expressly decided that. But the respondents here are being cautious and are taking the position that it does require 68 votes. So it really would be just about how does the House organize itself for a few days or a few weeks or however long it takes for the snowplows to get out there and get people into the office.
What about Wagner? So Wagner wasn't about the passage of a bill. That was about whether there was the constitutional problem was whether there was 2/3 to waive the reading of the bill, right?
Correct.
So doesn't that, and we decided that, doesn't that undermine your argument?
I think this goes to sort of the reasoning that the court has applied on the whole, right? Which is that when the court is deciding is a statute valid, has the legislature constitutionally enacted a statute? There's just different rules that come into play, right? So if this legislature tried to enact a statute, we'd be in a different ballgame, right? Where we wouldn't be talking about the same principles we are here.
Okay, thank you. A different topic on just the secretary in their reply. You didn't ever get a chance to respond to this, and in their affidavit talks about this question of whether the decision not to recognize Mr. Johnson's certificate of election was proper. So do you think there's a valid certificate of election for Johnson? And the House actually did vote to accept, I guess, right, the decision, but after the session initiated.
I have no idea whether there's a valid certificate of election or not.
Do you know who made the decision that certificate that was actually brought to the House by the secretary was decided that it wasn't a valid certificate of election?
I don't know. I think it's, when I read that, I thought it was very odd that the court was being told in one breath, you don't have to look at legislative minutia. And then in the next breath, it seemed that the court was being asked to solve the case of the missing election certificate, which certainly seems like legislative minutia to me. Our position is that that seat was vacant, not because of what happened to an election certificate in some back office somewhere. That seat was vacant because no one from that district showed up and took the oath of office or claimed to be elected to that seat.
But a bunch of people, other people worked. There were 133 counted, and many of them didn't show up either.
That's true. That would present another question. The Journal of the House reflects that the majority that was there accepted that oath of office that those members took in a different place. It doesn't really matter because we're talking about is 67 a majority? 67 is a majority of 133. 67 would also be a majority of 67 if that were the number.
No, but it's not of 134. So if you count, if Mr. Johnson's certificate was valid, then you lose under either argument.
We just don't think it's about the validity of the certificate. If there were a valid certificate, but the member died, or the member fled the country, or otherwise just never showed up, the seat would be vacant.
Can we talk about the Constitution now and what your view of the quorum clause is in our state constitution? And specifically, I want to talk about the relationship between the clause in the federal constitution and in our state constitution, and why, in your view, we should be sort of marrying ourselves to the interpretation of the quorum clause in the United States Constitution. What's your best argument for why we should be doing that?
So what I would say is the best argument is that it's what this court has previously said, and what the federal Congress does is just confirmation that this court's in good company, and there's no reason to change it, right? And I think the best way to do this is to walk through Eastland versus Gould and Peterson and what the court decided there. The question in Eastland is what is 2/3 of a quorum? I'm sorry, what is 2/3 of a vote, right? Is it 2/3 of a quorum, or is it 2/3 of all the seats, or some larger number, right? And what the court said, the way the court reasoned its way to that decision, was first to say, well, a quorum is a majority of the House. But wait a minute, the court said, just passing ordinary legislation takes a majority of all members, and that could be more than a quorum. That was the court's point of departure. And then they said, well, we think that the two supermajority requirements are more important than ordinary legislation, so it must be 2/3 of that greater number, right? Now, Eastland was an older decision. It wasn't written in the style that we would write now. I think that's the only fair way to read it. But if there were any ambiguity, 50 years later in Peterson, the court explicitly adopts this rule, says, yes, the way you refer to seats that include vacancies is by talking about all the members elected. And if you talk about all the members, or, and the Peterson court was explicit about this, if you're also talking about just a majority of the entire council or the body, that's the majority of the existing members.
Do you agree that, Peterson aside, just the plain language of the term members elected maybe doesn't evoke what this court said it does in the Peterson decision? I mean, just looking at the plain language, wouldn't you agree that it'd be sort of the opposite, actually, of what we said in Peterson?
I don't know I would agree it's the opposite. I would agree that this is a case where the plain language only gets you so far, right? I mean, the Constitution talks about the House. Well, what's the House? The Constitution says it's composed, members refers to members who compose the House. So is that people? Is that seats? There's different arguments that you can make. I think that the court's inference that, well, wait a minute, they talk about members elected in some places. They talk about just members in other places. They talk about the House in other places. Maybe members elected is supposed to mean something different, right? And then the court at some point stops trying to sort of wring meaning out of the text and looks at the structure of the Constitution and says, gee, it looks like these supermajority requirements are supposed to be things that are kind of important. So we shouldn't be looking at a denominator that's artificially small. And I think that's where we get the meaning of members elected that we do.
What role should ancient parliamentary manuals guide, or how should they guide our decision in this case? There's been some discussion. Ms. Kramer referenced Masons. There's been some talk about Masons in the briefing. Of course, there are other parliamentary manuals out there. How much importance should we be placing on those as we grapple with the meaning of the term under our own Constitution?
I would say not much. I think this court's decisions have set forth the way forward. I think the court's in good company. The manuals confirm that, right, that there's multiple choices here. Minnesota has made its choice. There's just no reason to reverse course.
Well, counsel, the manuals confirm more than that. Section 501 indicates that the rule that apparently the House has been following, according to the chief clerk of the House, is the majority rule in the country, that the total membership of a legislative body is to be taken as the basis for computing a quorum. Why isn't that information that we could rely on, particularly when the chief clerk of the House is apparently indicating that that's been the standard practice in this state for apparently as long as he's been in that position?
I don't understand. I mean, it has for a long time taken 68 votes, not because anybody thinks it's the total number of seats, but just because for a lot of the time, that was how many legislators there were, right? So both of the standards would have worked out to 68, and nobody explained which way it went. Now, as for, why shouldn't the court consider Masons? The answer is because this court's own decisions say something different. And when it's between this court's decisions and a book that somebody wrote, this court's decisions are what you follow.
And when you're referencing our decisions, you're relying on Gould and Peterson, and that's it, right?
As reiterated by this court in Ram Development in 1971, and as I've said, this court's in good company, right? I mean, there's a long tradition among many states, among many authorities.
Ram, there was 7 of 7, though, right? There were actually 7 elected, sitting, valid members. Just that was about abstentions. That's a little different.
So correct. People were asking the court to extend or even change the rule in Ram to say, well, maybe people who aren't there shouldn't count either. And the court said, basically, no, we like the rule we set before. We're going to stick with it. I'd like to speak to the public policy question, if I may. I think that it's actually a pretty clear call, if the court gets this far, that the public policy weighs to the side of the respondents here. The petitioner's argument would be, you need to make sure you have a broad base of representation for there to be a quorum. But realistically, what we're talking about is out of the 134 legislative districts in Minnesota, the question is, should 68 or 67 of them have representation on the floor in order for the House to take action? That just doesn't seem to move the needle
But
much.
counsel, what about those who are from the district that's unrepresented? I mean, granted, there's other issues with that, but what about them? And I think it's 40B, am I right? Jamie Becker Finn's old seat. What about those people?
So again, I mean, those people, if one more legislator shows up, those people are not going to be represented and there's going to be a quorum. And I mean, the remedy for them is a special election, which, you know, I know this court has on the mind and is going to happen, right? That's what our Constitution contemplates. But the other side of this, right? I mean, the time when you would get to serious questions about, wow, do we want such a small number of people operating the House for the whole state, would be if there were some kind of catastrophe, right? If there were a huge disaster that vacated a lot of seats. If that were to happen, I would suggest that the public policy concerns about the continuity of government would become much more important. And I don't think you need to just take my word for it. We've talked about there's a statute, right? The legislature has determined constitutional questions about that. I would note that the Constitution does have an attack clause that allows the legislature to provide for continuity of government. So there would be interesting questions there. But I think we know I think that's clearly the way the policy debate.
One of my issues with your policy argument is that due to Section 22, Article 4, Section 22, which you seem to concede requires 68 people to pass a law. Due to that, your policy argument only gets you so far. I mean, the legislature can meet and organize and maybe try to compel some more people to show up, but they can't pass laws under your own argument. Isn't that a significant flaw with your policy argument here?
Well, I think it means that there's line drawing going on here, right? How much do you want the legislature to be able to do or not do? And I would say that it's the entire modern legislative process that can happen under a quorum, short of actually voting on the law. But the best example is the Constitution's requirement that a bill be scheduled for 3 readings before it's enacted. The readings can be scheduled by a quorum. You can get all the way to the final vote. So the legislation could be teed up and ready to go by the time a new majority comes into place and you have 68 votes for it.
Can I just ask one question, which isn't, I just didn't pick up this argument in the briefs, but the Attorney General, the Secretary, argued that Section 23, because in the first paragraph it refers just to 2/3 of the House twice, and then in the second paragraph it refers to 2/3 of the members elected to each House, that they essentially are equivalent. Did you have a response to that? I mean, one is about vetoes generally, one's about line item vetoes. I mean, is there what do you think? What do you make of that argument?
Yeah, so I mean, essentially, the court's reasoning in Eastland was textual to a certain point, or logical to a certain point, and then functional, right? So it started off. We know what a quorum is. It's a majority of the House. We know what is required to enact legislation. It's a majority of all members. So what about this, potential inconsistency, or what about these supermajority
I think the inconsistency is actually in the language used. So sometimes in that Section 23, it just says 2/3 of the House. Sometimes it says 2/3 of the members elected to each House to do the exact same thing, which is to override a veto. And I don't think Eastland actually, again, I don't think that addressed the question of vacancies. But setting that aside, why isn't the argument that 2/3 of the House, your whole argument is that there's these two different, one of your main arguments, there's these two different language and we got to treat them differently. But it seems like Section 23 treats the phrase 2/3 of that House, or a majority of the House in the quorum context, and 2/3 of the members elected to each House as the same thing. That's, I think, their argument, having nothing to do with Gould and all of those cases. What's your response to that?
Yeah, I think both sides agree here that there is no grand theory that makes all of this language completely consistent with each other, right? We have to interpret it in light of tradition, in light of practice. We think that's on our side.
Thank you, Counsel. Your time has expired. Ms. Kramer, you have 5 minutes for rebuttal.
Thank you. First, I need to correct or more directly answer Justice Thiessen's question from before about whether the certificate of election is valid. It is valid, is our position. I have one of my election lawyers with me. So there's your better answer there. But I'd like to return to exactly
and why,
what Mr. Nelson.
can you explain why it's valid? Why you think it's valid? I mean, he did submit a letter saying, I made the difficult decision not to accept my seat. Why does that, isn't that him like saying, I'm actually not going to present my election? I mean, it's not just whether it's a valid certificate, but whether he presented it, right? And so did he, even if it's valid, did he present it?
So that I don't have an answer to. Apologies. But I do want to get back to the point also that you ended on with Mr. Nelson, because I think it's a really important point. And it relates back to what is the language in Eastman versus Gold and State versus Wagner, where it says whole membership and right all the members of the branch, and why Solicitor General does that include vacancies. So I'm going to start with kind of a reverse logical proof, which is Peterson versus Hoppe acknowledges that at least some language includes vacancies, right? Some language in these documents is broad enough to encompass members who have died or for some reason were not properly elected. It includes the whole body. Even though I don't think Peterson versus Hoppe applies here, right? Some language does that. And there it says members elected is the language that's sufficient to do that. And that's what respondents agree with. They say members elected can pull in everybody, even empty seats. And here in section 23, members elected is the same as 2/3 of that house. 2/3 of the members elected is the same as 2/3 of that house.
Do you think they were treating it differently because one's a line item veto and one's just a general veto?
Justice Thiessen, that wouldn't make any sense to me. I mean, it is conceivable. I haven't seen any evidence in the constitutional debates that they meant those to be different things. And again, the abiding principle as this court has addressed these different issues, albeit on very few occasions, like Wagner and Eastman, this court has said our Constitution is different from the U.S. Constitution because of Section 22 in Article 4, because of this special emphasis on majority rule. And this court takes that as a principle to mean we're going to interpret that so that the broadest number has to act in all of these occasions.
Can I just come back to your Section 23 argument? So your argument is that in Peterson, the court and everybody, well, I don't know if everybody agrees, but at least this is the respondent's position that when it says members elected, that means members of all the House, right? That including vacant seats, that's the denominator. And in Section 3 or Section 23, it uses that language and the language the House or that House interchangeably. And so then there's this other language that would be members of the, not like members elected, but just members of the House. That might mean something different under Peterson, but the other two things are the same.
Thank you for drawing together that last piece that I didn't say. My point is, if members elected to the House is everybody, right? Or 2/3 of the members elected to the House means 2/3 of everyone. Then 2/3 of that House in that same section also means of that House means everyone. And in Section 13, the one we're actually talking about today, it says a majority of that House, and that should also mean everyone. So it would be absurd for those last three words in Article 4 to mean different things in different places here. Similarly, there is no principled reason to treat, for example, Justice McCaig's example of folks stuck in a snowstorm as counting towards the quorum, or people who are on a significant medical leave or a parental leave as counting towards the quorum, but not people who have died or people whose election has been challenged. There's simply no principled way that anyone has put forward to treat those contingencies differently. A quorum should be a quorum. And the Secretary of State asked this court to issue the writ.
I think we're good, counsel. I want to thank all of the attorneys for the help that you provided the court here today. We will take this matter under consideration, and we will issue our opinion in due course, and we are adjourned. Thank you.